This text joins the three parts of the Cochrane library into one continuous explanation. It is intended as the main narrated script for a long explanatory video. The goal is not to begin with the universe, gravity, or singularity, but to gradually show why it makes sense to speak about a step of realization, history, an observation frame, local reality, legal fiction, and the return to verifiable fact. Welcome to the first part of the Cochrane library. We begin with a simple distinction. Reality is not the same as its record. A record may be a database, a protocol, a decision, a photograph, testimony, an algorithmic score, or a scientific model. All of these layers may be useful, but none of them is reality by itself. When the record becomes an untouchable authority, the system stops looking for reality and starts protecting its own image of the world. That is why this explanation moves step by step. First, we separate fact from description. Then we explain the smallest step of change, the emergence of history, the observation frame, local reality, and only after that gravity, singularity, and the audit role of Evo. Here, a Cochrane means the smallest admissible step of realization. It is not a finished particle and not a decorative name. It describes the moment in which a set of possibilities may become one concrete local event. As long as a state is only possible, it has no closed history. Once it is accepted as admissible, a step is formed. That step does not change all reality at once. It changes only what is possible, continuous and coherent inside the given frame. This is why Cochrane is useful as both a conceptual and computational basis for checking whether the next state still belongs to the system reality. When one realized step appears, a trace appears. When steps connect to each other, history appears. And when history has continuity, the direction of time begins to appear. In this explanation, time is not only a prepared axis for finished objects to move along. Time is the trace of realized change. Each new state carries the weight of previous states. It allows some next steps, excludes others, and weakens others. History is therefore not a passive archive. It is an active constraint that keeps the system coherent and prevents the next computational step from pretending to be true when it does not follow. The next layer is the observation frame. The same state may look different depending on where and how it is observed. The frame defines what is measured, what precision is admissible, which relations are valid, and what is already out of scope. Evo therefore cannot only take input and return an output. It must know the frame in which the state is judged. Without a frame, computation becomes loose number handling. With a frame, it becomes a controllable step inside a defined reality. This is where we separate a computation that merely calculates something from a computation that can defend why its result belongs to the chosen world. Once we have a step, history, and a frame, we can speak about local reality. Local reality is not a new universe freely created by computation. It is a field of constraints, relations, and continuity in which the next state may be realized. It includes measurable quantities, precision limits, previous history, relations between sources, physical or legal constraints, and the purpose of the computation. If the result satisfies these conditions, it may continue. If it breaks them, it should not disguise itself as completed truth. It should be marked as mismatch, a proposal for correction, or a reason for an audit run.
Only now does it make sense to bring gravity into the explanation. Not as a sudden jump into the universe, but as an example of a strong organizer of local reality. Known physics says that gravity is related to space-time curvature. In this model, it is interesting in another way as well. It may define the conditions under which time, causality, and coherence are locally measurable. A star, a planet, a black hole, or a galaxy is then not only an object in neutral space, it is also an environment that gives surrounding states concrete rules. This is why gravitational reality appears only after step, history, frame, and local constraint field are clear. A singularity is therefore not the first idea, but a boundary test. When a system is placed under extreme conditions, it shows which relations hold and which break. We do not only ask how ordinary reality moves toward a singularity. We also ask how reality would have to be configured for an extreme state to remain locally coherent. This is where the operator and the meta-operator appear. One holds the conditions, The other searches for a frame change that does not destroy the state. The result should not be arbitrary fantasy. It should be a map of conditions under which the chosen boundary state can still be understandable and auditable. In this logic, Evo is not only a check after computation. Evo is a reality gate. Each next state must answer a question. Does it follow history, keep the frame, respect constraints, and make sense for the stated purpose? A common system often moves from input to computation, result, and only then review. Evo moves the review inside the step. It does not claim to know truth in advance. It only refuses to advance a state that has insufficient continuity with the defined reality. That is why Evo is useful for audit, security, computation validation, and systems where a formally correct result can still be factually wrong. This is the practical reason for the whole structure. A computation may be precise, repeatable, and technically correct and still be wrong against reality. One wrong record, shifted frame, incomplete input, or broken historical continuity is enough. The next algorithm then works correctly, but inside the wrong world. The result is clean only formally. Evo therefore does not check only the final number. It follows the path, state by state, and asks whether the result was formed inside the defined reality. If not, it is not proof of intelligence. It is proof that the system can quickly and precisely calculate someone else's error. In this view, an error is not automatically guilt, fraud, or failure. An error is information about mismatch. The right response is not to hide it, but to identify where it appeared, what it broke, and how it can be corrected without rewriting reality. That is why Evo needs an audit trail. Assignment, frame, selected equation, matrix identifier, operator, intermediate states, timeline, and result. A public audit should not reveal the private core. It should show that the path existed, that it was repeatable in the given version, and that the result was not created by silently changing the rules. This ends the first part. The next parts show what happens when reality is replaced by fiction, and why Evo R is needed as a return to verifiable fact. With this foundation in place, reality, record, and computation are no longer treated as the same thing. The next question is, what happens when a system knowingly replaces fact with assumption, and then treats that assumption as truth? This is where the second part begins. Legal fiction. Fiction, when assumption replaces fact. The second part of the Cochrane library examines the moment when a legal system knowingly replaces fact with assumption. Legal fiction says that a certain state will be treated as existing for legal purposes, even if it may not have actually happened. The best-known example is fictional delivery. A person may never physically receive a document, may not learn about it, may not know its content, and may have no real chance to respond. After a statutory period, however, the document is treated as delivered. This creates a fundamental contradiction. The system knows that real awareness may not have occurred, yet it derives real consequences from that uncertainty. Deadlines begin, defense may be lost, a decision may become final, and connected systems may accept it as a finished fact. Cochrane highlights the difference between reality, record, and administrative state. Fiction must not become proof of fact. Legal fiction can be a procedural tool under certain conditions. It must not become proof that something actually happened. The sentence that a document is deemed delivered is not the same as saying that the addressee truly received it, read it, understood it, and had an effective chance to defend themselves. A decision that has become final is not automatically a decision that corresponds to reality. A deadline that has expired is not automatically proof that the affected person had a real chance to use it. And a registered entry is not automatically a true entry. Legal fiction may define a procedural consequence. It cannot change the past, rewrite physical events, replace evidence, or turn an unproven assumption into truth. The cascade of fiction. The most dangerous element is not a single fiction by itself. The danger is its continuity. An authority sends a document. The addressee does not actually receive it, or objectively does not learn about it. The system applies fictional delivery, and a deadline begins. The deadline expires, the decision becomes final, it becomes enforceable, and connected authorities accept it as a finished fact. The record appears in other databases, registers, and files. Each next system relies on the previous record without rechecking whether the original assumption matched reality. A closed loop is created. The first uncertainty is stored as a record.
The record becomes formal fact, and the formal fact becomes the basis for the next decision. In digital administration, this is especially risky, because data moves quickly, automatically, and often without individual review. Fiction and imbalance of power. In the relationship between an individual and public power, legal fiction is not neutral. An authority has access to registers, information systems, delivery data, logs, delivery confirmations, files, and often expert staff. The individual often receives only the final result. The deadline expired, the decision is final, or no remedy is available anymore. If fiction is used without real verification of conditions, inequality appears. Public power creates the record, evaluates its effect, derives legal consequences from it, and then uses it as evidence of proper procedure. The person is then asked to prove the opposite. This reverses responsibility. The state cannot fairly say, "Prove that you did not learn about the document," when the state itself had or should have had the data about the actual delivery process. Legal certainty must not stand against the person. The purpose of legal fiction should be protection of legal certainty. But legal certainty must not mean only the certainty of an authority that it can close a case. It must also mean the person's certainty that they had a real chance to learn about the proceeding, know the claims against them, have reasonable time to respond, present evidence, and use an effective remedy if the fiction did not match reality. Legal certainty created by suppressing reality is not real certainty. It is only an administrative closing of uncertainty. Such closure may be convenient for the system, but for a person, it may mean losing a right before they even knew they had to defend it. When fiction becomes systemic risk, it is necessary to distinguish between an individual error and proven systemic misuse. Without evidence, it is not correct to say that every use of legal fiction is abuse. But it is precise to say that legal fiction creates a structure, especially vulnerable to mass harm, when used automatically, without checking actual facts and without effective later remedy. Systemic risk appears when decisions are treated as delivered without checking reachability. Delivery evidence is refused, technical logs are not retained or disclosed, and connected authorities accept conclusions as finished truth. Fiction then changes from an exceptional procedural tool into a mechanism that gives an unverified assumption the effect of reality. The constitutional boundary of fiction. The constitutional boundary is simple. Legal fiction is not an unlimited power of the state. It is an exception whose use must be reviewable, lawful, proportionate, and compatible with the person's right to real defense. If statutory conditions are not met, a court or administrative authority has no right to simply declare the effects of fiction. Using fictional delivery at a wrong address may interfere with access to court and with the right to have a case heard in the party's presence. From the EVO perspective, a state must not enter system history merely because it is administratively convenient. It must be verifiable whether it met the conditions of reality, law, and continuity with previous events. Reality before fiction. In matters that may seriously affect a person's life, the principle should be reality before fiction. The harsher the consequence, the less the state may rely on fiction, and the more it must verify fact. Before enforcing a serious intervention, public power should prove not only that a document was sent, but also that it honestly checked the legal conditions of delivery, available contact data, technical circumstances, and the realistic possibility of awareness. If it later appears that the fiction did not match reality and that this prevented defense, the answer cannot be only that the decision has meanwhile become final. Finality may close an ordinary procedural step. It cannot legitimize an intervention created because the state replaced reality with an unverified assumption. Fiction must not become a shield against truth. The second part leads to a practical conclusion. If fiction, records, or administrative procedure can cover reality, another form or another checkbox is not enough. A return layer is needed, one that keeps the principle of reality before records. This is where the third part begins. Evo R. Evo R, From Records to Verifiable Reality, Part 3 of the Cochrane Library introduces Evo R, a reality-anchored framework for public administration, police, and justice. Its purpose is not to replace a judge, police officer, prosecutor, official, expert, or the law. EVO-R must not decide guilt, innocence, sanctions, risk, or the social value of a person. Its task is different: to ensure that every datum, item of evidence, computation, official act, and decision transition remains traceably connected to the reality from which it arose. EVO-R does not say, "This is truth." It says, "This is a claim. This is its source. This is its history. These are contradictions. This is missing. This was changed, and this can be verified." And if admissibility conditions are not met, the data must not be used as the basis of a serious intervention. Reality before records. The basic rule of EVO-R is this: a record is not automatic authority. A digital trace is not automatic evidence. An algorithmic output is not an automatic conclusion. Fiction is not automatic fact, and legal finality is not automatic truth. Every information item in a public system must carry its real state: claim, primary record, technically anchored evidence, derived datum, indication, disputed datum, corrected datum, excluded datum, or missing evidence. No datum may become a fact for decision merely because it was transferred into another database, included in a file, or repeated by another authority. EVO-R protects the difference between what actually happened, what was recorded, and what the system only formally accepted. Reality Admissibility Matrix EVO-R evaluates each step through 4 layers: evidentiary state, auditable history, legal and procedural conditions, and the set of objections, contradictions, and unsecured evidence. The output is not a judgment or a sanction. The output is an admissibility state. The system may say, "It is admissible to continue only with uncertainty warning, add evidence, preserve evidence, perform human review, do not use the datum as a basis for intervention, repair connected records, or reopen the procedure." The old model moves from datum to database, algorithm, decision, and enforcement. The EVO-R model moves from datum to source verification, integrity control, contradiction control, preservation of counter-evidence, human assessment, decision, auditable enforcement, and the possibility of repair. EVO-R must not control citizens. EVO-R must not be deployed as a crime prediction system, personal profiling tool, citizen score, mass surveillance system, or automatic sanction mechanism. It must not replace human credibility assessment or connect unrelated databases without lawful reason. Its basic function is negative limitation. EVO-R does not say whom to search for. It says what cannot be claimed without evidence. It does not mark a person as risk. It marks an evidence gap, contradiction, data change, or inadmissible procedural step. It does not create suspicion. It must prevent suspicion, records, or automatic outputs from being presented as proven reality. Police use reality protocol of an event. For police, EVO-R would act as an evidence capture gate. During a serious action, it would create a reality protocol of the event. It would include time, location, identification of involved officers and equipment, available camera and body cam footage, communication, GPS, photos, witnesses, and the list of secured and unsecured evidence. Each item of evidence would receive an evidence envelope with source, time, hash, device, operator, chain of custody, version, and integrity state. If someone points to a specific item of evidence, such as a camera or witness, refusal to secure it must not remain invisible. It must become an independent, auditable act. An evidence gap must not later be filled by assumption against the person who pointed to the evidence. Use in public administration. In public administration, EVO-R forbids turning a database into reality. Every datum transferred between authorities must carry original source, legal basis, verification date, scope of changes, responsible authority, and information, whether it is disputed, challenged, or derived by an automated process. A datum must not be verified merely because it comes from another state system. Transfer is not proof of truth. If a datum is corrected or marked as disputed, EVO-R must create cascading repair, identify where it was transferred, mark connected acts, notify responsible authorities, stop automatic spread, and show the affected person where it was used. A serious negative decision must not rest only on algorithmic risk marking, formal expiry of a deadline, or legal fiction. Justice use. Integrity pack of proceedings. In justice, EVO-R does not propose a judgment, moral evaluation, or sentence. It has one task: to show the court whether it is deciding over a complete, traceable, contradictory, disputed, or procedurally damaged image of reality. The court should receive an integrity pack of proceedings: factual timeline, procedural timeline, origin of each item of evidence, evidence changes, contradictions between sources, rejected evidence proposals, lost evidence, and procedural fictions. Fiction should have its own category: procedural effect, based on statutory construction. Factual state was not technically proven. A decision must explicitly mark evidence deficit, so the system cannot first fail to secure evidence and then claim that the person did not prove their version. Human rights inside EVO-R. Every person affected by public power decision-making must have concrete rights inside EVO-R. The right to audit trail, to know which data were used, where they came from, who inserted or changed them, where they were later used, and which rules processed them. The right to explanation, why the decision was made, which evidence was refused, what information the system did not have, and which conclusions are certain or only probable. The right to counter evidence, to add one's own materials and objections without automatic rejection. The right to correction and propagation of correction, so a faulty datum does not continue in other registers. The right to human decision and non-digital defense, because a digital process must not be the only path to protection of rights. Architecture, safeguards, and legal effect. Technically, EVO-R should be distributed audit infrastructure, not one central database. The source reality layer preserves original materials: video, image, sound, document, log, measurement, physical evidence, or testimony. The evidence envelope adds hash, time anchoring, signature or seal, source, device, and history of copying, access, and modifications. Evolutionary audit records every state transition, and the contradiction map shows conflicts between testimony, image, time, location, log, database, expert output, legal fiction, and later correction. EVO-R must not be operated and audited by a single subject. There must be separation of roles, public audit format specification, reproducible tests, versioning, external control, and forensic audit. The legal effect is simple. A serious public power intervention must not be based on data whose origin, integrity, legal basis, procedural continuity, or possibility of defense are not auditably documented. Closing. The whole explanation therefore rests on a simple rule. Record, model, fiction, and computation must not replace the reality they are meant to describe. QCranon names the step of change, EVO guards its admissibility, and EVO-R gives systems the requirement that a result must be not only formally correct, but auditably connected to fact.